Walter SEGO's first.
You're good.
All right, we'll go on the record in the state of Wisconsin versus Walter SEGO. It's 26 CF 93 appearances.
The state appears by Assistant District Attorney Thomas Valerio. Good afternoon.
Walter SEGO appears in person with Adam Gahelski appearing as friend of the court, though I will note that I represent him in 25 CF 2975.
Okay, but he might need to do something to get you retained in this case.
We'll have to discuss that, yes.
All right.
Sure, of course. KACHELSKI.
All right, and so Mr. SEGO, if you're not able to retain Attorney Kowalski, you can retain a different attorney, or you could potentially apply for a public defender if you're eligible. I'll ask the deputies to provide that information. If you get kind of caught in the middle, there's a thing called a county appointment that you could apply for, and Attorney Kowalski can probably point you in the right direction for those things if you're not able to retain him.
Absolutely.
Do you have a copy of the complaint?
We acknowledge receipt of the criminal complaint. The address on file is complete and would waive formal reading.
Right, we'll make a finding of probable cause and are not guilty pleas to the misdemeanors. We don't believe there's a public safety assessment. State's position on bail.
I apologize. I just need one moment. Okay. I'm recommending a $1,500 cash bond in this case. For conditions, I'm asking that the defendant have no contact with Lorraine S. Their first name is spelled LORRAINE. I would also ask that the defendant be banned from the 5,000 block of Violet Lane in Madison, Wisconsin, 53714. So Commissioner, it looks like there's an underlying case that was charged previously. That's Dane County case 25 CF 2975. In that matter, the defendant's alleged to punch the same victim involved in this new case twice, causing a visible black eye. The victim also reported a few weeks prior to that past instance that Mr. SEGO killed her cat that was healthy, hitting it to death with a piece of vacuum cleaner. Regardless, here, while on bail, he's escalating his conduct into physical violence by pulling his wife to the ground. This causes her elbow to fracture. She was granted Mr. SEGO was previously granted a signature bond. Contact wasn't restricted in that previous case. It was originally ordered as a no acts or threats of violence. But it looks like here it's alleged that he's escalating his conduct by victimizing Lorraine S. and committing an act of violence towards her. So this is an Act 3 case. It's coming on the heels of another Act 3 case involving the exact same parties. I think at this point, this is now the second felony associated between Mr. SEGO and Lorraine S. I think when we look at it through an Act 3 analysis, I think the specific victim here needs to be protected in the form of cash bail. So I think that cash is appropriate.
Great, and Attorney Kowalski?
Would have no objection to the non-monetary requirements. I do, however, believe a signature bond is appropriate here. Given the allegations, I think no contact absolutely isn't appropriate. I think that adequately protects the alleged victim here and the public. I think whatever is or is not going on, it is focused solely on these parties, and a no contact order should adequately protect the public. I will say, however, whatever conditions are ordered, I'd ask that he be allowed to go to his residence once with law enforcement to protect the peace.
And I should ask, do you know a better mailing address since I'm inclined to adopt the ban from Violet?
Unfortunately, at this time, no. I did speak to Mr. SEGO, and he indicated he probably will have to find a hotel because we did anticipate a no contact with the residence order.
Okay, well, when you sort out where you can get your mail, make sure that you update the court or Attorney Kowalski. You can sign up for text message reminders when we're done here. You'll have to sign some paperwork. Any response from the state?
I don't think that the no contact on its own is sufficient to protect the public. I think this is the second instance where Mr. Sego has allegedly victimized the exact same person. And this time he's doing it while on bail for doing the exact same thing earlier before. The earlier case was back in November. It's only January. We're already back with similar conduct. I think we need to start talking about cash bail at this point.
All right, and I don't have the benefit of a PSA. It's an Act 3 offense. Is there a prior record aside from the underlying charge?
So,
I don't believe so. Let me just double check that. Yeah, the only thing I can point you to is they're county disorderly conduct violations. I'll mention them because the victim in those cases was also Lorraine S. He was convicted of county disorderly conduct in November 2021. And then in 2015, he was convicted of county disorderly conduct. I do not know who the victim in that case was. I believe, well, my notes indicate that actually that also involved Lorraine S.
All right. Well, I think the non-monetary conditions are certainly appropriate. I'll order a no contact direct or indirect with Lorraine S., a ban from the 5,000 block of Violet Lane. If you do need to get any items, you got to contact law enforcement. Reserve a time to go with them. Don't show up there if you're not in their presence. That's a violation of the bond conditions. With respect to the cash bail, there's some things in his favor and some things that are not in his favor. In his favor, there's no prior criminal record. I don't put a lot of weight on, ordinances. I don't know whether those were provable cases. They weren't charged out as criminal cases or resulted with criminal convictions. It is quite concerning that we have nearly the same type of charge for somebody who was out on bail and made some promises to the court that they weren't going to direct any acts or threats of violence, then allegedly violated that. I think the complaint suggests that the victim may have ended up with a fracture as a result of the alleged conduct here. Obviously, it's all going to have to be sorted out at trial, but it is an Act 3 case. He was out on an Act 3 case. I think when he's shown, at least to the level of probable cause, that the non-monetary conditions weren't sufficient, I do think we need some cash. When I get to that analysis, I generally don't believe, modest amounts of cash bail are really sufficient to prevent people from committing other acts of violence. So I'm not going to go below what the state's requested here. I'll set $1,500 cash bail. Order no contact direct or indirect with Lorraine S., as I stated in the ban from the 5,000 block of Violet Lane. You do have the right to a preliminary hearing within 20 days. What's your position on that?
1 moment.
Sure.
Under the circumstances, I think we would ask that the time limits be enforced.
Okay, we'll get a preliminary hearing scheduled within the time limits in the next 10 days. If you want to hang on, since maybe you'll be representing him on this case, the clerk can let you know what we have.
Sure, at least find something that hopefully works and we'll figure it out the rest later.
Yeah.
So,
Tuesday, January 20th at 2:30.
at 2:30, you said? That should work for me if I am indeed the attorney on the case.
All right, we're adjourned.
Thank you.
Next is Shane Yelling Wager.
Right, and I don't know if the bails were updated as to some of the victims. I think if we can call Huey Smith and Flores Lozano sooner rather than later, that'd be great. Flores Lozano and Huey Smith, if I'm reading the email right.
Right. Oh. We'll try. Over there on the hill.
All right, we'll go on the record in the state of Wisconsin versus Shane Yelling Wager. It's 26 CM 119 appearances.
The state appears by Assistant District Attorney Thomas Valerio.
Good afternoon. Attorney David Bowles is appearing, making a special appearance on behalf of Shane Yehling, who also appears in person in custody.
Great, and do you have a copy of the criminal complaint?
We do. We would waive reading and stand mute.
And do we have a good address?
Yes.
Okay, I'll make a finding of probable cause. We'll get a not guilty plea entered to the charge. It's a standalone bail jump, so there's no public safety assessment would be done in that instance. State's position on bail.
I'm recommending a $750 cash bond in this case with the condition that the defendant be banned from the 2700 block of Dunwoody Drive in Madison. Dunwoody is spelled DUNWOODY. This is a pretty straightforward case, Commissioner. It's an instance where law enforcement was dispatched out to that address that I just mentioned because it was reported that the alleged victim in this case witnessed Mr. YEHLING appear at their residence, obviously in violation of the bond condition. This was a couple months after Mr. YEHLING allegedly violated the 72-hour no contact, which was, believe in 25 CM 272. Excuse me, that was in 25 CM 2741, which is where the contact after domestic abuse arrest case happened. So Mr. YEHLING continues to violate orders and lawful orders indicating that he needs to stay away from the individuals involved in this case, and he's not. He's violating a specific condition of bond. And then furthermore, the reason why I'm coming up with the 750 is because in the 2741 case, I think bond was originally set at 500. So I think that the 750 I'm proposing here is a reasonable step increase from that instance.
All right, and so he's out on $500 cash bail in that underlying case?
Right, that's right. That was set in November of last year.
Great, and Attorney Bowles?
Thank you, Judge. I can let you know that Shane is a lifelong Madison resident, has no prior history, no convictions, I should say. He does have a couple of the pending matters. I would say they're all nonviolent. But obviously the allegation here is that he was present outside of his former household checking mail, which we can understand sometimes why the motivation might be to do that, particularly when mortgages are going unpaid and things like that, and you have a separation. Doesn't mean it was lawful if that's what happened, but it wasn't an attempt to contact or have any sort of violent contact with any of the occupants like that. And so I don't think that there's any basis to conclude that he's a physical threat to anyone. I think this does so lapse in judgment, but I don't think it affects his ability to appear in court. There's no basis to conclude that he wouldn't appear in court based on the cash that's already been posted. I can tell you that he is barely at the point where he could post any more cash. So at this point, significant cash up to the point that they're requesting would potentially mean indefinite incarceration until, something changes. So I would ask the court, if the court does find that some cash is appropriate, to make a lower finding of that amount so that he could potentially post it. I am making a special appearance, so he may now qualify for either SPD or for court appointed. So
All right, I
That's
appreciate that, and maybe if you said that earlier, I overlooked it. So, sir, if you cannot retain Attorney Bowles, you can contact the Public Defender's Office, see if you're eligible for a lawyer. The deputy's giving you that information. You could hire an attorney if you're able to, or apply for a county attorney, which is the middle option. And it sounded like, and I don't want to misconstrue what was said, Attorney Bowles, are there other cases aside from the underlying case that he has pending? Or are we just talking about the two pending cases now?
No, he's got, so besides this one and the contact after domestic abuse arrest, he's got 25 CM 2724 that involves a count of obstructing or resisting an officer. And then he also has 25 CM 2748, which involves a count of criminal damage to property as an act of domestic abuse.
All right, and I think the reference was 25 CM 2724 was nonviolent, but did that involve the same victim as well or not?
So my understanding is that, yeah, so 2724 involves one count of disorderly conduct as an act of abuse towards the individual with initials JEY. Not sure if it made it into the complaint, but JEY was present in the residence when it's alleged that Mr. YEHLING WEGER was there. So yeah.
All right. Well, Mr. YEHLING WEGER, I don't think you're in a great position when you're already out on cash bail and then we have violations of specific conditions. It's not the worst violation in the world. There isn't an allegation of physical violence or something of that nature, but it's concerning that we now have our third case and they involve the same people here in these particular cases. I think there's a need for some cash bail. I'll set it at $500. I don't know that 750 is necessary, but I think there's a need for cash bail to make sure that you appear in court, given the continued violation of bond conditions. I will order a ban from the 2700 block of Dunwoody Drive. And was there a specific request for no contacts with HY and JY?
No specific request from me. So I just left it at the 2700 block of Dunwoody. There's similar no contacts throughout the rest of the cases, so I'm not asking for it.
Okay, well, if it isn't being asked for, I won't order it, and we'll be adjourned if there's nothing further.
There is one more thing, Your Honor. I misspoke earlier. The address does need to be updated, and I think he has it, but
It's at my mom's house, when it says 48 Bel Air Drive and Highland Manor trailer or
well, and did he maybe update the address in the underlying case since he was already banned from that address? Maybe the clerk can see if we have a Bel Air Drive address for him.
and if it didn't, I can update the court once I have that specific address.
So on Spillman, it says 48 Bel Air Drive, Madison. Does that sound right, sir? All right, well, it didn't say on Spillman. Do you know the zip?
I'm told 53713.
Okay,
There you go.
if there's nothing else, we'll be adjourned.
Thank you. Here, Shane.
Next is. Aaron Williams. William.
My friend.
Yeah, what's right?
Great. We'll go on the record in the state of Wisconsin versus Iran Williams. It's 26 CM 112 appearances.
State appears by Assistant District Attorney Thomas Valerio.
Write that down. Good afternoon, Your Honor. Mr. Williams appears in person with Counsel Anthony Delier. It's a special appearance for purpose of this hearing only. We've received a copy of the complaint, waived the reading, and need to update the address.
Okay, where's a good mailing address?
8551 Elderberry Drive.
no, that's a duplex actually.
Okay.
8551 Elderberry,
Yes, sir.
and the zip code.
537. Shoot, I'm not quite
All
sure.
right, we can probably have the clerk Google that just to make sure that we've got that. So it sounds like Attorney Delier, he would have to do something to retain you yet.
Yes.
All right, so Mr. Williams, if you're able to retain Attorney Delier, great. If you can't, you could hire some other attorney if you're able. If you're not able to, first stop should be the public defender's office. The deputy's going to give you their contact info.
Retainer.
Okay. I will make findings of probable cause and are not guilty pleas to the charges. There is a public safety assessment report. Not scrolling, there we go, recommends a signature bond. Attorney Delier, if you didn't receive that, I assume Attorney Nagy's, Attorney Leon gave it. Appreciate that. State's position on bail.
I have no objection to a signature bond. I would ask that the defendant not use or possess any controlled substance or drug paraphernalia without a valid prescription.
Right, any objections?
No, sir.
Okay, we'll order a signature bond. Condition will be that you not use or possess any controlled substances or drug paraphernalia without a valid prescription. It looks like you've got a hold for a contempt of court. That's a separate issue. I can't address that here today. If you're able to post the purge amount, then you could get released. If not, you'd need to address that with the family court that set that. Okay, we'll be adjourned.
Thank you.
Thank you, Your Honor.
You're welcome.
This PAOLA, GUTIERREZ, hearing via Zoom.
Right, we'll go on the record in the state of Wisconsin versus PAOLA GUTIERREZ. That's 26 CM 106 appearances.
The state appears by Assistant District Attorney Thomas Valerio. I appear in person.
I have information that Ms. Gutierrez wants to represent herself, so I'd ask the court to inquire with her.
Okay, and Deputy, perhaps you can unmute Ms. Gutierrez. All right, and Ms. Gutierrez, can you hear me okay?
Yes,
All right, and were you planning to represent yourself today, or did you want the assistance of the public defender, who's a very experienced lawyer, to assist you for purposes of today? If you want them to help you, you're not locked into having a public defender for the rest of the case. You can always retain an attorney on your own after today or represent yourself. Did you want to represent yourself, or do you want the public defender to assist you today?
can the public defender assist me?
I'm sure Attorney Nagy would be willing to do that.
Yes, that's fine. And you are Paola Gutierrez, correct?
Yes,
Are you currently receiving mail at the Beacon?
at Aberg.
Aberg? Okay, we'll get that address updated.
And-
Paola,
Both.
okay, Paola Gutierrez appears from the Dane County Jail by Zoom and by counsel appearing especially Aaron Nagy. I've received a copy of the criminal complaint. Waive its reading. The address should be updated to 1819 Aberg Avenue. I will waive reading of the complaint if I didn't say that already.
All right, and so Ms. Gutierrez, I just want to talk to you about your right to an attorney after today. I kind of went over that a little bit. If you want a public defender after today, you'd need to give them a call and get evaluated. We'll make sure that you have their contact information for that. You're certainly free to hire an attorney on your own. If you're kind of caught in the middle, you could apply for a county attorney, and you do have the right to represent yourself, but that may not be advisable. And since you're using the Aberg Job Center, it might not be a bad idea to sign up for text message reminders if you've got a working cell phone. When they have you sign some paperwork when we're done here today, you could do that if you're interested in that. I'll make findings of probable cause and are not guilty pleas to the charges. I don't see a PSA report. State's position on bail.
I have no objection to a signature bond. I would ask that the defendant be banned from Meriter Hospital, which is located at 202 South Park Street in Madison, Wisconsin, except for legitimate medical emergencies and medical appointments. And then I would ask that the defendant have no contact with Officer Cody C., except in his official capacity as a law enforcement officer.
No objection.
Okay, so Ms. Gutierrez will order a signature bond here. I think you're going to get released from custody. I don't see anything else holding you. Conditions of that bond will be a ban from Meriter Hospital at 202 South Park Street unless you have a medical appointment or there's a medical emergency, and that you have no contact, direct or indirect, with Officer Cody C., except as necessary in the ordinary course of their duties as a law enforcement officer. And we'll be adjourned.
Next is Huey Smith. It works yellow stuff.
Oh.
That's your copy. Do you have any trouble with English? And this is the correct, is this the correct address for you?
Yeah.
Okay, I can't talk to you about it. So I'll have to. And it looks like you're on your Joe and your places are the same where you are.
All right, we'll go on the record in the state of Wisconsin versus Huey Smith. It's 26 CF 94 appearances.
The state appears by Assistant District Attorney Thomas Valerio.
Huey Smith appears in person in custody and by counsel appearing specially Aaron Nagy. I've received a copy of the criminal complaint, as has Mr. Smith. Waive its reading. Address is correct. And He is eligible for a public defender.
Right, I'll make findings of probable cause. Get not guilty pleas entered to the misdemeanors. I don't believe there's a public safety assessment. I was informed we may have a victim who wanted to make a statement. If that person's on Zoom, and it looks like if they are, they would be on a phone. You'd need to hit *6 to unmute. And then just identify yourself however you're comfortable for our court reporter, okay? And again, if we have the victim in the Huey Smith case who wanted to make a statement, you just need to unmute. If you're on Zoom, it looks like it would be *6 to unmute.
I can't hear.
All right, I think the person is unmuted. Are you the victim in the Huey Smith case?
Hello, yes,
All right, and can you just identify yourself however you're comfortable?
I'm John Sullivan.
What's the first name again?
John.
John Sullivan. All right, and Mr. Sullivan, what did you want to say about bail or bond conditions?
I just have to keep people out of my house. There's too much traffic here, and I'm under order, so I don't. I can't have this anymore with all the traffic, and people bring the traffic in.
Okay, so just to be clear, it sounds like you want Mr. Smith to not have contact with you and not be at your residence?
I don't want him to have anybody in my house.
Okay, so he can be there, but you don't want him bringing friends over?
I can't have anybody here. I'm under an order for an abatement on my house, and they say they don't want people here. And the day this occurred, there 3 people came into my house and they would not leave, and they're not anybody I know, and that's where I'm at on that.
Okay, but again, I just want to clarify, are you okay if Mr. Smith were to come back to your residence or have contact with you, or would you like us to order him not to do those things?
I have to do a legal eviction on this.
Okay. Well, I guess that maybe suggests to me that you don't want Mr. Smith back, but maybe we'll hear from, you can put your hand down, Mr. Smith. You got an experienced attorney, and she probably doesn't want you saying anything because this is all being taken down, and anything you say could be used against you later on. If you want to say things that you think are important quietly, then she can make sure you don't accidentally say something that incriminates you. And then if Mr. Sullivan didn't have anything else that he wanted to say, we'll hear from the state and their position on bail.
I'm recommending a $500 cash bond in this case with the condition that the defendant have no contact with John S. and that the defendant be banned from the 3500 block of Spencer Lane. Just one moment. And Spencer is spelled SPENSER. I think the prevailing reason why we're asking for cash is because Mr. Smith was on bond when this alleged offense occurred. It looks like I'm looking at his appearance history. I don't see any recent failures to appear. He's got some older ones he has like 4 bench warrants from 2019. Those are probably a little too old for us to consider incredibly relevant. Was attending court. I know he's got 24 CF 785 open right now. It looks like he's been attending court regularly in that. But still, he's on bond in this case. Has a condition not to commit any new crime, and he's here doing that. So I think that some cash is necessary.
Okay, and Attorney Nagy.
He's been on bond for over a year in the 2024 case. It looks like probably close to 2 years, given the case number is 2024 CF 785. He is indigent. He's eligible for a public defender. He's not working right now. He's lived in Wisconsin his entire life. He's been appearing for that 2024 case. We're asking for a signature bond.
All right. And if I order the no contact, is there someplace else that he can reside?
I think Mr. Smith is under the impression that Mr. Sullivan is willing to have Mr. Smith back at his residence, but as long as he does not have company over.
Okay, well, if Mr. Sullivan wants to unmute, because to be honest, and maybe it was me, I was a little confused as to whether he just wanted Mr. Smith not to bring any third parties over, or he also wanted Mr. Smith not at the residence and was going to pursue an eviction. And Mr. Sullivan, if you wanted to, again, weigh in on that, it would be *6.
I wasn't done. How do I? Hello?
Yes, we can hear you.
Yeah, I am under an order by the police department. I have to meet them tomorrow about the traffic that's happening at my house, and I have no guarantees that I can't follow through with people if they continue to bring people here, and I've tried to get that to the people. I don't.
Okay, and I understand that, and I just want to be very clear. There's a dispute in regards to a couple of the bond conditions, and there's a request that I order that the defendant have no contact, direct or indirect, with you and be banned from the 3500 block of Spencer Lane. Is that what you're asking the court to do, or you're not asking the court to do that?
Well, what happens after that if that's violated? If I'm keeping everybody out of my house, and if that's violated, what's my recourse on that?
Well, if I were to enter that as conditions of bond and Mr. Smith didn't comply with that, you can contact law enforcement. He could potentially be arrested for a bail jumping charge.
I've got to have that safeguard, because people will just keep coming here, and I'm trying to stop them from being in my house. I'm under the order to do it. And I want to know if it's just going to be the same thing all over again.
Okay. Well, I appreciate your input, Mr. Sullivan. Anything else from the state or defense in regards to the bond?
Not for me.
I still think there's a misunderstanding with Mr. Sullivan regarding, Mr. Smith, let me make the argument. Mr. Smith lives there. I think the issue is Mr. Smith having people over. Mr. Sullivan keeps talking about other people, and I don't think that he's referring to Mr. Smith. I think Mr. Smith would be fine with a condition that Mr. Smith not have any company over to the residence. So I'm not sure if my understanding is Mr. Sullivan may be hard of hearing. And so I guess if the court is on the verge of making one determination or the other, we ask Mr. Sullivan more pointedly whether he wants Mr. Smith alone at his house.
All right. Well, I thought I asked it pointedly, but I guess we'll ask one more time. Mr. Sullivan, do you want the court to order that Mr. Smith not have contact with you, regardless of whether he's with anybody else, and be banned from your residence? Oh, and you're muted, so you'd have to *6 to unmute.
Oh,
Yes.
don't do that. Hello?
Yep, we can hear you, Mr. Sullivan. Can you hear me?
Oh, yes.
All right. And do you understand the dispute between the parties here? Mr. Smith thinks that you agree that it's okay for him to come back to your residence and have contact with you as long as nobody else is with him.
I have to start evictions. The police want everybody out of my house. And I don't know what my legal part is. With this letter I got, it said, take this letter as a 5-day eviction. And I've got to follow the law. I'm trying to follow the law, and I don't want to illegally evict someone, but I've got to follow what the police said. Now, I don't know how this law plays out.
Okay. All right. Well, I appreciate it, Mr. Sullivan. I am going to order the no contact. It is a Act 3 offense. It's a battery. I want to make sure that we don't have further issues. I don't see this as a cash bail case. While it's an Act 3 offense, I'm not satisfied that the history requires cash bail in order to protect Mr. Sullivan. I expect that Mr. Smith's going to abide by the no contact and the bond conditions. And while it's concerning that you've picked up a new case, it wasn't a specific condition of bail. It was the general condition. So I'm going to order a signature bond. I'll order no contact direct or indirect with John S., a ban from the 3500 block of Spencer Lane. If
Am I allowed to go there to get?
Yep, I'm going to talk about that, Mr. Smith. So contact law enforcement, arrange for what's called to preserve the peace. But you have to be in the presence of law enforcement, you know, walking with them. Don't show up there. Don't be in the 3500 block of Spencer Lane without law enforcement. That'll be a violation. Even if Mr. Sullivan were to change his mind later on and reaches out to you, you don't want to respond to him. You want to walk the other way. Talk to your lawyer. They could file a motion to get the bond change. If Mr. Sullivan changes his mind, he can write the judge to ask that bond to be changed. I think that's his right as a victim. He could also reach out to the victim witness people with the DA's office to ask them to file a motion in regards to the bond. Is there some other place that we could send mail on a temporary basis, sir?
Do you use the Beacon or
I've never
paper?
been there. Yeah, I guess I could just use their.
The Beacon or
Yeah.
Aberg? Which one's closer?
Aberg.
Aberg, okay,
Food stuff. Yeah.
okay, so 1819 Aberg,
And I
please.
see why people like calling down and would see nothing. Like
Yep.
something must have-
Yeah.
Yeah, so it would be the Madison Police Department. I'm not sure which district that would be for Spencer Lane, but if you call Madison non-emergency line, I'm sure they can get you forwarded to the correct district if you tell them what's going on and the address to get that set up. If you do have a working cell phone, not a bad idea to sign up for text message reminders. I think the signature bond's appropriate. You got to make sure that you show up to court, and you can't be picking up more cases here. But I took into account the lengthy time that you were out on bond without mission court or picking anything else up. What about time limits?
They're not waived at this time.
Okay, we'll get a preliminary hearing scheduled in the next 20 days, and we'll be adjourned.
All right, you're good to go.
Thank you, sir.
Next is Flores, Lozano.
You said Flores Lozano?
Yeah, yeah. Brad, Lozano. All day? Flores, Lozano? Yellow lights. That's fine.
Great, we'll go on the record in the state of Wisconsin versus Jose Flores Lozano. It's 26 CF 92 appearances.
The state appears by Assistant District Attorney Thomas Valerio.
Jose Flores Lozano appears in person in custody with attorney Miles Leon.
Great, and do you have a copy of the criminal complaint, Attorney Leon?
Yes, Your Honor, we have received a copy of the criminal complaint. At this time, we'd waive any further reading. My understanding is that he is not eligible for the public defender and that the address on the complaint is correct.
All right, so Mr. Flores Lozano, the deputy's giving you the public defender information. So Attorney Leon is going to assist you today. If you can't hire an attorney on your own after today, you should apply with the public defender's office to see if you're eligible for one. If not, then you could apply for a county attorney. That's the middle option. And I'll make findings of probable cause. We'll get a not guilty plea entered to the misdemeanor. I don't see a public safety assessment. And I believe that there was no victim that wanted to make a statement. And I don't see anybody on Zoom, so we'll hear from the state, their position on bail.
Okay. Well, first I want to mention that the victim in this case wishes to have contact with Mr. Flores Lozano, but asks that the defendant not use or possess any firearms. I have no objection to a signature bond in this case. I would ask that the defendant exhibit no acts or threats of violence towards Maria G., that the defendant not use or possess any dangerous weapons as that's defined by the Wisconsin statutes, and that he not use or possess any alcohol.
All right, Attorney Leon, any objections?
No objection, Your Honor. We join in the state's recommendation at this time.
Okay, I'll order a signature bond. Conditions will be that you direct no acts or threats of violence towards Maria G., that you not use or possess dangerous weapons as that's defined by the state statute. So that includes firearms, other things that are designed as a weapon, but it includes just about anything else that you can think of if you're using it in a manner that's likely to cause great bodily harm or death, or you're threatening to do that. So I think a good example is like a baseball bat. You can play baseball with that, you're fine. If you're threatening to hit somebody with it, then you can't possess that. We'll order that you not possess or consume any alcohol. And I'll just warn you that if you come back and you're violating these specific conditions, there may well be a no contact, and you're not going to be able to have contact with this person. There's also the potential for cash bail. These are a couple of Act 3 eligible offenses, so make sure that you abide by these conditions faithfully. What about time limits for the preliminary hearing?
One moment, Your Honor.
Sure.
Okay. Thank you, Your Honor. Based on him being, the signature bond being set today, I have discussed time limits with him and he is okay with waiving them for the purpose of the preliminary hearing.
Okay, makes sense. It'll give you more time to get a lawyer. We'll set it for a status conference and we'll be adjourned.
Thank you.
Next, is it Ricardo?
Yes, it is. Sorry, my first name is Ricardo, middle name Miles.
I want to make sure. Thank you.
I appreciate, no, you're right. I need to be better about it because that's what it is on all the e-filing.
Next is Diane Maroney, appearing via Zoom.
I think that's just a forfeiture. I was hoping to get ours. Eight. All right, we'll call the County of Dane versus Diana Maroney. It's 26 FO 85 appearances.
The county appears by Assistant District Attorney Thomas Valerio. I appear in person. The defendant Diane M. Maroney appears via Zoom in custody without counsel.
All right, Ms. Maroney, if you can hear us okay, give us a thumbs up in the window. All right, see a thumbs up. So good news, I don't think you're getting charged with a crime, even though you got arrested for a crime. The DA's office has charged you with county disorderly conduct. That's a non-criminal charge. It's more like a speeding ticket. So that's not going to hold you in custody. I think you're getting released today no matter what. The county will have an offer, and if you want to accept that offer, then you could just be done with the case. If not, that's fine. You're still going to get released. You'd need to show up for future court dates. If you didn't, then you could get defaulted. We've got an address on the complaint of 11316 South Bell Avenue, Chicago, Illinois, 60643. Is that still a good place to get mail? All right. Attorney Valerio, the county's offer?
It's court costs only.
Okay, so if you wanted to accept that, you'd have to pay $114.50 in the next 60 days or work out a payment plan. Did you want to accept that and enter a no contest or guilty plea, or would you like to contest the charges and enter a not guilty plea?
I'll pay that fine.
I'm sorry, you said you'll pay the fine?
Payment plan.
Okay, so you want to accept that offer and be done with the case. I'll take that as your no contest. I didn't catch that part.
I said, yeah.
Okay, so I'll accept that as your no contest plea to county disorderly conduct. Order you to pay the court costs of $114.50. They're gonna process you. You should get released yet today in the next hour or so. And they'll give you some information about sending in the payments. If you need a payment plan, just contact the clerk of court's office and you can arrange for that. We'll be adjourned.
Next is Ramon Munoz for a forfeiture. YEHLING.
All right, we'll call the County of Dane versus Ramon Munoz Jr. It's 26 FO 86 appearances.
County appears by Assistant District Attorney Thomas Valerio. The defendant, Mr. Ramon Munoz Jr., appears in person in custody without counsel.
All right, and Mr. Munoz, I believe they've given you the forfeiture complaint alleging county disorderly conduct. So the good news is that's a non-criminal charge. I don't think anything else is holding you, so I think you're going to get released today no matter what. They are going to have an offer. If you want to accept that offer, then you can just be done with this case. If you don't, you're still going to get released, but you got to make sure you make your future court dates, otherwise you get defaulted. Okay? County's offer.
Court costs only.
Right, so it's gonna be $114.50. It doesn't have to be paid up front like bail or anything. Did you want to accept that offer and enter a no contest or guilty plea, or do you want to contest the charges and enter a not guilty plea? All right, I'll take that as your no contest plea to county disorderly conduct. Or do you pay the court cost of $114.50? They're gonna give you some envelopes to send in the payment and they'll process and release you yet today. Any questions? Okay, we are adjourned.
This way. Next is GABRIEL R STEWART. GABRIEL YEHLING.
Great. We'll go on the record in the state of Wisconsin versus Gabriel Stewart. It's 26 CF 95 appearances.
The state appears by Assistant District Attorney Thomas Valerio.
Gabriel Stewart appears in person in custody with attorney Miles Leon. This time we have received a copy of the complaint. It would waive any further reading. My understanding is the 130 Flint Street address in Sun Prairie is correct and up to date, and currently he's been found ineligible for the public defender.
Okay, so Mr. Stewart, let's talk about your right to an attorney. The deputy is going to give you the public defender info in case you need it, but it sounds like you were found ineligible, meaning you make too much money. You certainly can hire an attorney on your own after today. If you're unable to do that, you could reapply with the public defender. There's also the option for a county attorney. That's kind of the middle option, and the public defender can point you in the right direction for that. I'll make a finding of probable cause. I don't think there's a PSA report. State's position on bail.
Okay. I have no objection to a signature bond in this case. I would ask that the defendant have no contact with Dayshia W. Their first name is spelled DAYSHIA.
Okay, and any objections?
No, Your Honor, at this time we join in the state's recommendation.
Okay, I'll order a signature bond. Conditional be a no contact director and direct with Dayshia W. And then we should talk about time limits. You have the right to a preliminary hearing in the next 20 days.
This time, Your Honor, we would be enforcing time limits.
Okay, and it doesn't give you a lot of time to get a lawyer. Make sure you do whatever you need to do if you're gonna get a lawyer and not represent yourself at that, okay? We are adjourned.
This way, sir. If that's right. Next is Elijah Aliomar, appearing via Zoom.
All right, we'll go on the record in the state of Wisconsin versus Elijah Aliomar. That's 26 CM 113 appearances.
The state appears by Assistant District Attorney Thomas Valerio.
Elijah Aliomar appears via video from the Dane County Jail. Attorney Miles Leone appears in the courtroom. This time I have received a copy of the complaint. Would waive any further reading. I will inform the court that I don't believe he was able to be evaluated by our office, so I'm not sure of his eligibility status. And then obviously I can't talk with him. I'm not sure of his current address, Your Honor.
Okay, so I think Mr. Aliomar, they've unmuted you. Is there a good place for you to get mail?
Right now at the moment, I'm incarcerated.
Okay, are you being held on other things other than this? Because I didn't see anything else holding you.
No, I am not.
All right, and so if you do get released today, and I don't know what's gonna happen with bail, is there a shelter or a friend's place that we could send mail
Yes,
to?
normally go to the men's shelter for the time being. The Beacon, the men's shelter, Safe Haven.
Is that the 4006 Nakusa, or is you talking about a different one?
That's the exact one I was talking about. That's a day shelter.
Okay, great. We'll get that updated. If you do have a cell phone, you can.
Oh, as a matter of
sign up.
fact, yes, I can use this as soon as I get up out of here. I can use that as an address, but I will have to let them know I need to use their address as an address for my mailing. But yes.
Okay, and you could also get signed up for text message reminders if you have a working cell phone. And then we should talk about your right to an attorney, Mr. Aliomar. Sounds like they weren't able to evaluate you. If you need an attorney after today, and you can't hire one, give them a call and see if you're eligible, okay?
Yes.
All right, I'll make findings of probable cause. We'll get not guilty pleas entered to the charges. I don't see a PSA report. What's the state's position on bail?
I have no objection to a signature bond. I would ask that the defendant have no contact with SGL, that the defendant be banned from the 400 block of South Bird Street in Sun Prairie. The victim in this case supports the non-monetary conditions.
All right, and any objections?
No objection, Your Honor.
Okay, we'll order a signature bond. Condition will be a no contact director and direct at the victim with the initials SGL and a ban from the 400 block of South Bird Street in Sun Prairie, and we'll be adjourned.
Next is ASHON BRIGGS. Mr. Brandon. Paper killer.
Right, we'll go on the record in the state of Wisconsin versus ASHON BRIGGS. It's 26 CF 96 appearances.
The state appears by Assistant District Attorney Thomas Valerio.
Sean Briggs appears in person in custody with attorney Miles Leone. We have received a copy of the criminal complaint, Your Honor. At this time, we'd waive any further reading. He is eligible for the public defender, and the address listed on the complaint is correct and up to date.
All right, thank you. We'll make a finding of probable cause because it's a standalone bail jump. There's no PSA report that would be done. State's position on bail.
I'm recommending a $500 cash bail in this case with the condition that Mr. Briggs not operate a motor vehicle. The basis for the cash, Commissioner, is that Mr. Briggs was on bond in this case on January 11, 2026 with a no drive condition. That underlying case is Dane County Case 25 CF 2657. In that earlier case, law enforcement pursued Mr. Briggs for approximately 5.7 miles during an initial traffic stop pursuit, and he had to be found approximately 3 hours later, parked at a tire factory, or excuse me, the vehicle that he was driving in was parked at a tire factory, which was found 3 hours later. So the court ordered him to not drive, and he's here violating that condition of bond by driving, even though he's on bond for an offense where it's dangerous for him to drive. So I think that some cash is appropriate.
And Attorney Leon.
Thank you. At this time, we'd be requesting a signature bond or a significantly lower cash bond. First, I would just note that Mr. Briggs is eligible for the public defender, makes him by definition indigent. So I do think a small amount of cash, if cash is necessary, can be used to assure his further appearance, as well as any compliance with the non-monetary conditions. I would also note that he has, I think, in my opinion, very strong ties to the area, currently residing in Madison. It looks like he's lived here for his entire life, and he has some family here, including his children. currently has employment at the Dane County Airport that I believe he's held for about 3 years as well. Finally, while I do understand the state's concern and understand he was out on bond here, I think what's actually most important is the fact that why he was pulled over. It wasn't because he was driving recklessly or anything like that. It was more or less happenstance where they ran his registration of the vehicle and it came back showing that it was suspended for an unpaid ticket. So I do think that cuts in Mr. Briggs' favor, understanding that the allegations are something he wasn't supposed to be doing, at least while it was being done. If it is true, he wasn't doing it dangerously or in a way that I think comports with the behavior that the state is really concerned about here. So for those reasons, we'd be asking for a signature bond or a low cash bond, Your Honor.
All right, well, I think it's a close call. It's concerning when you're violating a specific condition of bail. It's concerning that he's got the underlying charge. To his credit, as noted by counsel, it wasn't a fleeing situation. He wasn't doing other dangerous driving, drunk or drug driving or any of that. He is not supposed to be driving at all because it was a bond condition and because his license is suspended. To his credit, it looks like he pulled over when law enforcement contacted him, and we didn't have any of the alleged behavior that that was alleged in the underlying case. I'm going to give you an opportunity with a signature bond, Mr. Briggs. I'll order that you not operate a motor vehicle. You can't do that. If you're back here a third time, there might be a compelling argument for some cash bail. Because you're making promises when you're signing your bond, and if you keep allegedly breaking those promises, then I start not to trust whether you're going to follow other promises like showing up to court. What about time limits for the preliminary hearing, Attorney Leon?
We are asking to enforce the time limits, Your Honor.
Okay, we'll schedule a preliminary hearing and we'll be adjourned.
Thank you.
Next is Jennifer Shields for a bail bond.
I'm sorry, did you need a moment? The clerk just needs a moment. So I don't know that I've ever experienced the construction that loud. Is that something we're gonna be
Ooh,
all the time?
that was
It's been regular being asked. Yellow.
All right, we'll call the state of Wisconsin versus Jennifer Shields, 24 CF 488. Appearances.
the state appears by Assistant District Attorney Thomas Valerio.
Thank you, Your Honor. At this time, we have received a copy of the complaint and would waive any.
Actually,
My bad.
Attorney Leon, I don't believe we need to do an initial appearance. We did one on July 9th of 2024. And then allegedly the defendant failed to appear on August 22nd, 2024 for the preliminary hearing. So we were just here to address the bond. She previously had a signature bond and a condition that she not use or possess controlled substances or drug paraphernalia without a valid prescription. I'm not sure that the address that we have on file is still the best place for mail. Are we still using the Aberg Job Center for mail?
For mail.
Okay. And then do you know about eligibility for an attorney, Attorney Leon?
She is eligible, Your Honor.
Okay. And any information that you want to provide about the failure to appear, Attorney Leon?
Just one moment. Your Honor, I would just put on the record that Ms. Shields has informed me that she didn't believe she received that in the mail and was not aware of the missed court date due to that.
Okay. Attorney Valerio, your position on bail?
I'm recommending a $1,000 cash bond in this case with the prior non-monetary conditions to remain. Ms. Shields has a history of absconding for various periods of time, Commissioner. I'll start in 2019 because I think it's relevant when we're talking about the pattern of conduct. Looks like she had a bench warrant issued in September of 2019. That wasn't served on her until December of that same year. And then on August 9th of 2022, a bench warrant was issued in Dane County Case 22 CF 1276. That wasn't served on her until almost a year later on June 21st, 2023. And then on August 23rd of 2024, in the case that's, I believe, before us today, she's been in warrant status for that whole time. She just got picked up or served with it on January 11th, 2026. This looks like a simple possession of drug case. So I'm sensitive to the fact that this isn't a more serious offense or an Act 3 eligible offense. We still need Ms. Shields here, though. She's been out on a signature bond that obviously hasn't worked. I'll note for the record that in May of 2024, we tried to do, I believe, an out of custody IA for her. We adjourned for personal service in April. The second time around in May, we just had to issue an arrest warrant on Ms. Shields. And yeah, that appears to be the history of the case. So I think that $1,000 is warranted.
Okay, and looking into the matter a little closer, it is pretty clear to me that Ms. Shields was personally served or provided a notice in court, and that's also consistent with the procedure that would happen at a commissioner status conference. It's the status conference where person shows up, they get their next court date from the commissioner in hand before they leave. It also looks like, as noted, I see a PSA at the time of the initial appearance had her almost at the top of the scale for failure to appear, 5 out of 6. Had multiple failures to appear, some of which may have been outlined by Attorney Valerio. Attorney Leon, your position on bail?
Thank you, Your Honor. I do understand the history that's been placed on the record by the state here and why it can be concerning to the court. I think what's very clear, and just from this brief conversation I've had with Ms. Shields, is that she is struggling with homelessness. And I do think that that goes to why court is being missed. I don't think I have to go into any detail to understand that even if she was handed that date that day, I think once you're back out in the community looking to kind of find where you're going to be each day and how to survive that, I think that at times does take precedent. This is not to say that court isn't important. I think it's just important to look at this situation and what Ms. Shields is facing on that day to day. So I would say that her non-appearance in this history that's been placed on the record, I think it can be attributed to homelessness, and rather than her just blowing off court, not finding it important. And I do think that does cut in her favor. I'm not suggesting that she's being punished for being homeless, but I do think it puts us into a bit of a gray area where we do get close to that, where somebody who doesn't have those resources, isn't able to keep track, is worried about where they're going to be each day. They might not make it to court, but I don't think that necessarily means that they need to have such a significant cash bond as what the state's asking for. So we'd still be advocating for a lower cash bond or a signature bond, Your Honor.
All right. So I'm not going to hold the failures to appear on April 25th, 2024. It looks like they had tried to send some notice, tried to get her served. That didn't occur. But there's an extensive failure to appear history. Aside from that, she was out on the warrant for over 2 years. This is not somebody who it's their first foray into the criminal justice system. Clearly, she knew this case just didn't go away, and she took no steps to, show up to the courthouse or show up to the jail or contact the public defender to address things and say, I lost my paperwork. I may have missed a court date, when there's so much time in between the failure to appear and now. There's a need for cash bail. I'm willing to set it at a lesser amount, given it's a nonviolent drug offense. I'll set it at $600 cash bail. I guess the benefit of having done that is if she wants a prelim in the next 10 days, we can get that scheduled as opposed to a 20-day prelim.
We would be enforcing the time limits then, Your Honor. Thank you.
Okay, makes sense. We'll get a prelim scheduled in the next 10 days. The prior non-monetary condition in regards to the possession of drugs or paraphernalia will remain and will be adjourned.
Corrections. Next is, do we have a BARBEE? Yeah. No, bring it apart. And yeah, like, sorry. No, what is your? You can mail it for like others.
All set?
Yes, thank you.
All right, we'll go on the record in the state of Wisconsin versus Brianna Barbie. It's 26 CF 91 appearances.
The state appears by Assistant District Attorney Thomas Valerio.
Brianna Barbie appears in person in custody with Attorney Miles Leone. We do have a copy of the complaint, Your Honor. We'd waive any further reading at this time. She is eligible for public defender representation. I do have an updated address to provide to the court. It would be 430 South Yellowstone Drive, apartment 408. That's in Madison, and I believe the zip code is 53719.
All right, thank you. We'll make findings of probable cause and are not guilty pleas to the misdemeanors that apply to Ms. Barbie. And we don't have a PSA report. What's the state's position on bail?
I'm requesting a $2,000 cash bond in this case. For conditions, I'm asking that the defendant have no contact with Darren J. Their first name is spelled DARREN as in Nancy. And then no contact with Briisha M. Their first name is spelled BRI''ISHA. I would also ask that the defendant be banned from the Crystal Corners Bar in Madison. This case involves Miss Barbie getting into an altercation at the Crystal Corners Bar. One of the individuals started screaming stuff at one of the other individuals involved, and then Miss Barbie pulled out a can of OC spray and sprayed Johnson, or one of the two of the individuals involved. The staff started screaming for everyone to leave, and one of the other involved individuals went outside. Once outside, that individual was punched by a different individual. And then during the altercation, Miss Barbie struck, I believe it was Delisha S. with Miss Barbie's vehicle. Delisha S. gets into the vehicle. Miss Barbie drives around Sergeant Sissoko at this point, who has his lights on, which is clearly indicating a seizure, that they're not allowed to leave. And Miss Barbie gets away from the scene. Miss Barbie is then takes Sergeant Sissoko on a I believe it's a regular speed pursuit, where Sergeant Sissoko eventually catches up with Miss Barbie. Miss Barbie walks away from Sergeant Sissoko when he caught up with her. So look, I think here Miss Barbie has no criminal convictions. From what I can tell, that means no prior instances of failing to appear. But this is charged out as a second-degree recklessly endangering safety. It's a serious case. It's Act 3 eligible, and involves an instance where Miss Barbie is allegedly fleeing from law enforcement. I think that $2,000 is appropriate. I think it fairly contemplates the fact that we're looking at a fleeing where Miss Barbie is walking away from Sergeant Sissoko after he catches up with her, and contemplates the fact that we're looking at an Act 3 case with the other facts in her favor, which is that she hasn't had any criminal history as far as I can tell. So I think that some cash is appropriate.
And Attorney Leon?
Thank you. At this time, we'd ask that you consider a significantly lower cash bond or a signature bond in this matter, Your Honor. Miss Barbie is eligible for the public defender. She is indigent, so I think even a more small amount or modest amount of cash would be able to assure her appearance to any future court dates, as well as just totally being in line with any of those non-monetary conditions that have been requested by the state here. That said, what we really are asking for is a signature bond in this matter. Understanding that the case that's before us is somewhat serious, especially the way the state is characterizing it at this time. I do think she has some things that really cut in her favor. She has extremely strong ties to the area, currently residing in Madison, providing the court with a mailing address in Madison that can help assure that she knows when her next court dates are. My paperwork shows that she's lived in the area for her whole life, and does have significant family here, including parents and siblings. As far as the event itself, I just think that some of the weight that's being put on the fleeing and eluding and the action or the allegation that Miss Barbie walked away from the officer at the end, I don't think the amount of weight that's being put on it right now is reasonable. And the reason I say that is because the way the complaint reads is when the officer, I think Soshoka that pulled up and would have been the officer pursuing Miss Barbie, he was on the scene when they were already getting in the cars. I do see that it does say in the complaint he flashed lights, but I do think that that particular interaction is very short. It's very quick. And obviously the tensions were high at that time. I think it's different than if an officer pulls up behind you while you're on the road, then flashes their lights. And there's that kind of moment where you see them coming on behind you. So I do think that does cut in her favor, at least to an extent. Finally, I would just note that it's noted in the complaint, which is pulled from the officer's report, that he was very far from the vehicle. And I think that's more why there was time for her to start walking away from the vehicle. It was because he was very far away. He didn't have his lights on at this time. It was a regular speed pursuit. And there was a point in the complaint where it says that he could barely see the headlights of Miss Barbie's vehicle. So I think that is more attributed to the fact that the officer was not in sight when she was getting out of the vehicle, rather than making a further attempt to flee or elude that officer. So I just don't believe that those instances really cut as deeply as the state is making them at this point. I do think there's some reasons for why that unfolded that way. And for all the other reasons I've placed on the record, we would be asking for a signature bond or a significantly lower cash bond.
All right, thank you. Any response from the state?
I think it's incredibly concerning when a law enforcement officer is at the scene, they have their lights activated, they're clearly signaling that that individuals at the scene are seized. Miss Barbie's reaction is to get into her vehicle and, regardless of how high tensions are, cause the incident that is alleged before her in the criminal complaint. Someone very well could have been seriously injured. Thankfully, no one was, and you should consider that as part of an Act 3 analysis. It's incredibly concerning. This wouldn't have happened if Miss Barbie had just stayed put. I recognize that this isn't a high-speed pursuit. It's not one where she's going across the county, swerving in and out of lanes of travel. I think that's also fair for you to consider. But that doesn't mean that this isn't a cash bail scenario. It's still fleeing. It's still an Act 3 second-degree reckless. So I think that cash is appropriate.
All right, let me just take a closer look at things. All right, well, obviously, the true nature of all the facts and whether the state's going to be able to prove things is going to have to be dealt with at trial. The behavior is certainly concerning in a couple of aspects. One, alleging that she was driving a vehicle while this other person was on the ground who then got hit by the bumper of the vehicle. It certainly could have been extremely serious. We're lucky that we're not here for a homicide or something more serious. It's an Act 3 eligible offense. In her favor, though, when I take into account the totality of the circumstances, the need to protect the public, the concerns of intimidation, the prior violent offenses, she's got no prior criminal record. Then when law enforcement comes on scene, they allege that they put their lights and siren on. The defendant then takes off at a fairly high rate of speed, although it doesn't suggest that it was 100 miles an hour as noted by Attorney Valerio, but even a high rate of speed in the area where she allegedly took off is a area that's often frequented by people walking and certainly people in vehicles. And it suggests that may have nearly struck the officer's vehicle. There's a paragraph about that, but then even if I were to accept that she didn't know that law enforcement was looking for her, then we have her leaving the vehicle and taken off at that particular point. The resistive obstructive behavior, the fleeing, eluding behavior to me is not consistent with somebody who's going to voluntarily show up in court. When people engage in that behavior, you're putting yourself at risk. It's just dangerous behavior. There's risk that you'll be injured. There's certainly risk to other members of the public and law enforcement. I guess where I see this, because I think it is an important factor to take into account, the lack of prior record is kind of somewhere in between. I'm going to set $1,000 cash bail, order a no contact direct or indirect with Darren J and Brescia M, a ban from the Crystal Corner Bar. And given the alleged driving behavior with respect to the victim that was allegedly hit and with respect to law enforcement, I'm just going to order that you not operate a motor vehicle right now. I'm concerned that if you're not going to make good decisions in a vehicle, somebody's going to get seriously hurt, and potentially you. We can schedule a preliminary hearing within the next 10 days. Attorney Leon.
We're gonna enforce the time limits, Your Honor.
Okay, we'll get it scheduled for a timely preliminary hearing. Certainly your attorney can file a motion. That's an opportunity to have bond reviewed, and certainly the facts can be fleshed out a little more at a preliminary hearing as well. We are adjourned.
Next is Destiny Sanders.
We'll go on the record in the state of Wisconsin versus Destiny Sanders. It's 26 CM 110 appearances.
The state appears by Assistant District Attorney Thomas Valerio.
Destiny Sanders appears in person in custody with Attorney Miles Leon. We have received a copy of the complaint. At this time, we would waive any further reading. She is eligible for the public defender, and she's about to inform me of her current address. Would you be able to?
Okay.
This is the 316 RETHKE Avenue, which is where my uncle Donald, y'all know Donald J. Johnson said, or 1898 Great Avenue. I think it's 52704 or 14. I don't know, you know.
Okay. Well, and I think I heard 3 potential addresses. Where is the place that you think it's best for you to get mail and you? Rethke. Okay, sounds good. We'll get that updated. We'll make a finding of probable cause and or not guilty, please. There's no PSA report. State's position on bail.
I have no objection to a signature bond. I would ask that the defendant not be on any Metro bus.
Great. Any issue with the bond or conditions?
No, we joined in the state's recommendation, Your Honor.
Okay, we'll order a signature bond. Condition will be a ban from any Madison Metro bus, and we'll be adjourned.
Next is Odine Ivan.
Yep, you too.
It works yellow.
Yep. We'll Go on the record in the state of Wisconsin versus Odine Hyman II. It's 26 CM 118. Then we also have a bail bond hearing after a failure to appear, and that's case 24 CM 2807. Appearances.
The state appears by Assistant District Attorney Thomas Valerio.
And Dean Hyman II appears in person in custody with Attorney Miles Leone. We do have a copy of the complaint, and we would waive any further reading at this time, Your Honor. He is eligible for the public defender, and I believe that 922 West Badger Road, Apartment A, Madison, Wisconsin, 53713 is an accurate address.
Okay, thank you. All right, well, Attorney Leone's trying to avoid you saying anything because we're recording everything. Anything you say can be used against you. You have the absolute right to remain silent. So he's just trying to protect you here. We'll make findings of probable cause in the new case and are not guilty pleas to the misdemeanors. Then we need to address bail in both cases. What's the state's position?
In the, 1 second. In the 26 CM 118 case, I'm recommending a $500 cash bond with a condition that the defendant have no contact with Ricky P. Ricky's first name is spelled R-I-C-K-Y. I would also ask that the defendant be banned from the 900 block of West Badger Road and that he not use or possess any alcohol. And then in 24 CM 2807, I'm asking that the signature bond in that case be turned into a $250 cash bond with the same non-monetary conditions that were previously ordered. It looks like Mr. Hyman has been in bench warrant status since August of last year in his 24 CM case. He's had prior failures to appear on November 4th, 2021 and November 25th, 2019. So I'll note that it doesn't look like he ever turned himself in from that last missed court appearance. He had to be picked up in the case that's before us today. So I think that some cash is appropriate.
Thank you.
Attorney Leone.
Thank you, Your Honor. At this time, we would be requesting a signature bond in both files or just a significantly lower cash bond than what's being requested here today. Mr. Hyman is eligible for the public defender. He is by definition indigent, so I think a smaller amount of cash could be used here to assure his further appearances at future court dates as well as compliance with any of these non-monetary conditions. From what I see here, I think he has extremely strong ties to the area. I believe he's been a resident of Dane County for all of his life or a vast majority of his life, currently provided the court with a address in Madison for mail. And my understanding too is that he currently holds down a job at Premier Labor and has held that job. Well, then I'll strike that. He's currently volunteering in the community though, which I do still think counts as a connection here and shows, I think, his dedication to Dane County. That should count in his favor as well, Your Honor. That said, my understanding about the missed appearance here, which I understand is concerning to the state as well as the court, is that he was in contact with his attorney at that time, and they, I guess, from his understanding, their representation of him either ceased or they left the office / retired, so they no longer were in contact with him. And his understanding at that time was that they were, I think, appearing on behalf for him in court in that way. So I don't think it was his intention to miss court that day. I don't have anything to provide about not addressing the warrants sooner. But for all the other reasons I've placed on the record, Your Honor, we would be asking for a signature bond in both matters or a low cash bond. Thank you.
Okay, well, so I'm not sure that he actually had a lawyer. He was approved for a public defender. But I don't see that anybody got appointed until after the failure to appear on August 20th of last year.
Okay.
I think there's a need for some cash bail, given the appearance history. This isn't the first time he's missed court, and he's been out on a warrant for, about 4 months and then picks up another case. I'm willing to set a little bit lesser bail and actually think 24 CM 2807, because that's the Act 3 eligible offense and is the battery, warrants a higher bail than the state asked for there. I'm gonna set $400 cash bail there with the prior non-monetary conditions. In 26 CM 118, I'm gonna set $150 cash bail there. I think that because it's a disorderly conduct is less serious and there's less incentive not to appear. Order no contact direct or indirect with Ricky P. and the ban from the 900 block of West Badger Road. Mr. Hyman, you had your hand raised. I just want to make sure that you're not going to talk about the facts of the case because that's maybe not advisable. If you have a question, I am certainly happy to answer that, or you can talk quietly to Attorney Leon to make sure you don't say anything that gets used against you later on.
It's not any question, sir. It's just, please, about understanding the actual kind of situation, or the actual bond situation. I volunteer in the community picking up trash. I also volunteer in community working at futures when I can. I have no funds at the moment. I've been waiting for unemployment from the coronavirus. And literally, they were barring me from actually getting to actual pantries to volunteer. They were barring me from getting in the community for picking up the trash. And literally, I have been really a good standard person in the community. And I do actually can have actual income doing this with being in this actual sort of a set situation because of the situation of me actually being a person that also assists to keep an order and structure. I've even been kind of picked on in accordances because it's in the work that I do is kind of like officer in accordances, but really lower authority. I don't have authority to a serious extent. And really, it's just been a situation of really very much recruited on this. And I promise you that I will make sure that I come to the actual court. I just really was relying on my actual person, meaning my lawyer, to actually really working with me in the actual manner.
Okay, well, I appreciate that, Mr. Hyman. I've made my decision. I'm not gonna change that decision here. You did make a promise previously that you were gonna show up to court. In fact, you make that promise every time you're out on bond, and this is allegedly the third time that you haven't shown up in court. What we can do for you is, because I think you're public defender eligible, they'll get you a lawyer. We'll make sure you have the contact information. They could file a motion to review the bail because these are misdemeanors. I think they're going right to the branch. I may have neglected, if that was requested in the new case. I just ordered the no contact with Ricky P and the ban from the 900 block of Badger Road. Did the state request a no alcohol condition in that case as well?
I did, and that I only requested in the 26 CM case.
I think it's an appropriate condition. I overlooked it. It looks like alcohol was on board, so I'm going to order that you not possess or consume any alcohol. Mr. Hyman, do you have a question?
I was scared that day because of literally the way it had my.
Okay, well, I don't know that you want to say anything about the facts of the case. This is all being recorded. It can be used against you later on. You probably want to talk to your lawyer. I'm not revisiting the bond. So this is the bond that's set and you'll need to go with the bailiffs, okay? Good luck, sir.
Next to Jason Playman for a forfeiture. Playman? Playman? No.
Yeah, right.
Delaware.
All right, we'll go on the record in the County of Dane versus Jason Playman. It's 26 FO 87 appearances.
The state appears by county appears by Assistant District Attorney Thomas Valerio. The defendant, Mr. Jason K. Playman, appears in person in custody without counsel.
All right, and sir, so the good news is you're not getting charged with crimes. I think they arrested you for some crimes. They've decided to charge you out as a non-criminal matter. The charges specifically are county obstructing resisting officer and county disorderly conduct. Those are more like speeding tickets as far as severity. They're not going to keep you in custody after today. I'm not seeing anything else that's keeping you in custody. So you are going to get released today no matter what. But they also will likely have an offer. And if you want to accept that, then you can just be done with the case. If you don't want to accept it, that's fine. But you would need to show up for future court dates in order to not get defaulted. Is that 411 St. John Street in Green Bay still a good mailing address for you?
No, it's
Okay.
615 Beacon is.
Oh, the East Washington,
So-
615, the Beacon.
May I please speak on my behalf a little bit, Honor?
Well, you can, couple things. One, anything you say is, I think, potentially going to be recorded, or maybe not, because it's a forfeiture, but there's other people listening who could testify against you. Two, today's not the trial. So they're going to have an offer. If you want to accept that offer, great, then you can be done with the case. If not, you're going to get released because nothing else is holding you, and then you'll have future hearings to address that. I don't have a lot of option to do much different here
Okay,
because today's not the
I
trial.
will remain silent, but yeah, I don't think I actually did anything wrong other than being drunk.
Fair enough.
I went to.
And we can get a not guilty plea entered for you on both of these if you want. But if you also wanted to hear their offer, we can do that as well.
What is the offer?
The county's offer would have Mr. Playman plead no contest to either count. He can choose. I would dismiss the remaining count that he elects not to plead no contest to, and it would be for court costs only.
Okay, so if you wanted to accept their offer, you can pick which count you wanted to plead to, have the other dismissed, pay court costs of $114.50, either in the next 60 days or work out a payment plan. Did you just want to enter not guilty pleas and contest the charges, or would you like to accept their offer and enter a no contest or guilty plea to one of the charges?
I just really would like to say what had happened. I had gone into.
Okay, that's not a good use of your time because Mr. Plowman, they've offered court costs. I can't do anything lower than that, just so you're aware. So there's nothing I can do that's better than that. If you want to think about that.
Excuse me, I'm just trying to figure out.
You can enter a not guilty plea.
Ordinance, you said?
So, Commissioner, what I would inform Mr. Playman is that this is only an ordinance. It is not a criminal conviction.
Okay, I will take,
And if you're not sure, Mr. Plowman, you can always enter a not guilty plea at this point. They keep that offer open till the pretrial. But I'm not, pardon?
Then would I be on bond stipulation?
No, this is non-criminal. There's no bond. There's nothing to post. You're gonna get released today no matter what.
Yeah, I'm gonna go with the not guilty because I feel like I was not guilty.
Yep, that's fine. And I'm not trying to be disrespectful about not listening to your version of the case. It's not something that I can do anything about here today because this isn't the trial. It's a non-criminal matter. So we'll get the not guilty pleas entered. If you want to preserve your right to a 6-person jury trial, you need to make a written demand within 10 days of today's date and post $36 non-refundable jury fees.
Okay.
If you don't do that, you still get a trial, but it would be in front of the judge. They'd hear all the evidence and act as your 1-person jury. If you want an attorney after today, you'd have to hire your own. This is a non-criminal matter. One cannot be appointed for you.
But I will be able to represent myself.
Yep, you'll be able to represent yourself. You'll be able to discuss the matter with the DA's office who's assigned and see whether you can work terms out. And if you can't, or you decide you want to accept their offer, then you can be done with it at the next hearing. If not, it'll get set for a trial. If you don't show up for the future proceedings, though, you get default, just so you're aware of that.
The paying customer left my bag behind. I went to come back, pick it back up, and she told me to leave, the door shut. I said, I'm leaving with my property, walked out the exit, and then I'm getting arrested. And I said, this is my stuff.
Next
Okay.
is David Sanders.
Take care.
I went to pick up my stuff on the.
I know that thing.
So I need the paperwork, can I get all the paperwork?
Out there, okay, go out the door. Sanders, David. Paperwork, yellow X. Yellow X there on the floor.
Sorry, I didn't catch some.
Sanders.
David Sanders.
Okay, we'll call the County of Dane versus David Sanders. That's 26 FO 88 appearances.
County appears by Assistant District Attorney Thomas Valerio. The defendant, David R. Sanders, appears in person in custody without counsel.
All right, and Mr. Sanders, the good news is you're not getting charged with a crime. So let me explain the process here because it's a non-criminal matter. So We're not gonna be setting bail. You're gonna get released on this charge. I don't think anything else is holding you. So you're gonna get out today. They're actually gonna have an offer. If you want to accept that offer, then you can be done with the case. What they've charged you with is county bail jumping as a domestic. And I think we're using the Aberg Job Center as a mailing address. Is that the correct address?
Yes, yes, Your Honor, I all this matter happened, because I misunderstood you. I misunderstood you said I couldn't go in that building, because you said 74 hours. She said she.
Okay, well, I don't want you to say anything right now,
My-
because
they
it could potentially be used against you. I just don't want, and today's not the trial. I'm not gonna hear any of the evidence. This
Okay,
is
sir.
a non-criminal matter. We're not setting bail. You're gonna get released no matter what.
Okay, yes,
But
sir.
they will have an offer, and if you want to accept that offer, then you can be done with it. So, would you like to hear their offer?
Yes, I want to hear everything. This time I want to hear more clearly, because last time we talked, I didn't understand everything.
The county's offer to resolve the case today is to have Mr. Sanders plead no contest to the sole forfeiture charge for court costs only.
Plus the DV surcharge would be $214.50. I don't think I can waive that. Just give me a second here. So, Mr. Sanders, your options are to either accept that, enter a no contest or guilty plea, be done with that charge. You have 60 days to pay, or you can work out a payment plan. It's not like something you have to post up front. If you don't want to accept that, you can enter a not guilty plea. It'll get set for further court dates, and ultimately a trial if you do want to exercise that right.
In other words, you said about what, which I did have, I missed the job from good job. So in other words, if I get a job and start paying that money, then this will be totally done? That what you're saying, sir?
This particular case that you have right in your hand there, yes. Yeah, it's not resolving 26 CM 70. So the bond there and the ban from the 800 block of West Main Street, and the no acts or threats of violence towards SW, those conditions are still in play, and you'll have to show up. Looks like you got a pretrial conference March 17th at 2:15 on that. So that's a separate issue. But this is the non-criminal charge.
Deal with this, sir, one thing at a time. Yes, sir. I'll do that.
Okay, so you just wanted to accept their offer and just be done with it.
I got no money now, but I'm willing to go get a job. Yes, give me a job. I'm willing to pay it. I don't need to get this everything. Now, I done 7.5 years in prison for nothing I didn't do, for murder. When they found out I had no fingerprint of murder, that they said I had to take it off. They come back, take it. So I just took it. It was 7.5 years. They not done.
Okay. Well, just so you know, you don't have to take their offer on this particular charge if you don't want to, but I want.
I got no money. Never called them. Let me think back.
Okay, but so you're telling me you do want to accept the offer on the non-criminal charge of county bail jumping and be done with the matter?
Yeah, give me a job. I want today when I
Okay.
got here, I want to give me a bad day,
Yep.
my daughter's birthday.
No problem.
I'll tell them what find me a job. If I get a job, I'm gonna pay this. Put it on my record. I'm gonna pay this, sir. I don't want
Okay.
to file me chargeable.
So I'll enter a no contest plea to the charge, order you to pay the court costs. I can't waive the court costs or the DV surcharge, so it comes.
What's it?
They charged it as an act of domestic abuse. So that adds the $100 to it. So it's $214.50 to be paid within the next 60 days or work out a payment plan.
I work at a payment plan, sir.
Yep, just contact the clerk's office. Yep, just contact the clerk's office. You should get processed and released yet today, so go with the bailiffs. That's, you're welcome.
Next is Christopher Boyce. Boyce.
We'll go on the record in the state of Wisconsin versus Christopher Boyce. That's 25 CM 2925, 25 CM 2687. Then we have bail bond hearings in 25 CM 1287 and 25 CM 203. Appearances.
The state appears by Assistant District Attorney Thomas Valerio.
Christopher Boyce appears in person in custody with Attorney Miles Leone. I do have copies of all the complaints, Your Honor. We would waive any further reading at this time. Mr. Boyce remains eligible for the public defender. And his current address, he's directed me to inform the court that it's the job center. I'm sorry, I don't know the actual address for that.
You mean 1819 Aberg, the
Yes.
job center? Yep. So the clerk, I think's familiar with that one. We'll update the address, and you can always sign up for text message reminders too if you're interested. So we'll make findings of probable cause in the two new cases and are not guilty pleas to the charges. I believe there's a public safety assessment report in 25 CM 2925 that recommends cash bail. And then we have to address bail in 25 CM 203. There was a failure to appear on December 1st in that case, so gonna guess that's the same in 25 CM 1287, but let me pull that up. Yep, that's the same. What's the state's position on bail in each of the cases?
1 second.
And I guess it looks like he did have $150 cash bail posted in 25 CM 1287. And I guess the clerk's saying he also posted the same amount in 25 CM 203. I don't believe that that's ever been forfeited, so he has that available in both cases.
Okay, so in the bail bond cases, so in 25 CM 1287 and 25 CM 203, I'm asking that the $150 cash bonds in each respective case be each turned into $500 cash bonds. I'm not asking that you forfeit the money. So the money that he posted can apply to those under my recommendation. And then in 25 CM 2687, I'm recommending a $500 cash bond there too, with conditions that the defendant have no contact with Elizabeth S. and that the defendant be banned from the 300 block of Powers Avenue. And then in 25 CM 2925, I'm recommending a $2,000 cash bond with condition that the defendant have no contact with Elizabeth S. All right. So it looks like the two new cases involve Elizabeth S. One is a battery, disorderly conduct, domestic abuse case. That's the 2925 case. And then 25 CM 2687, I think is a violation of a violation of the specific no contact with Elizabeth S. He also has in the bail bond cases, it looks like 1287 also involves Elizabeth S. as a named victim. And then 25 CM 203 also involves Elizabeth S. as a named victim. So each of these cases has instances where Mr. Boyce is allegedly committing crimes against Elizabeth S., violating bond conditions or mixture of the two. And then he's also got appearance risk history. He's had bench warrants issued on July 16th, 2025, July 24th, 2025, August 25th, 2025, and December 3rd, 2025. On that last warrant I just mentioned, he wasn't served until January 9th of 2026. And I'll note that I believe, so misdemeanor batteries is an Act 3 eligible offense. I see that Mr. Boyce was previously convicted of second-degree recklessly endangering safety in Dane County case number 12 CF 103 for an incident that occurred on January 7th of 2012. It looks like he was sentenced to 2 years of initial confinement followed by 5 years of extended supervision in that case. And then in 2007, it looks like Mr. Boyce was convicted on a different instance of second-degree recklessly endangering safety for an incident that occurred on February 19th, 2007. So when I look at all that, I think that cash is obviously appropriate. These are obviously misdemeanors, right? So we're not looking at something with as high of an exposure as what Mr. Boyce has had to contend with in the past. But specifically, what we're looking at are a body of cases where Mr. Boyce is allegedly victimizing the exact same person. That person needs protection from Mr. Boyce during the pendency of these cases. And he has a appearance risk history that doesn't evince a lot of confidence in me that he's going to appear for court to answer for these charges. So I think given all that, I think that cash throughout the cases is appropriate, and I think that the non-monetary conditions are also appropriate.
And Attorney Leon?
Thank you. At this time, first regarding 25 CM 2687 and 25 CM 2925, I understand in those cases, the arrest warrants were put out about 2 different times. Mr. Boyce explains to me that he did not receive a notice in the mail for those 2 files. And so that's what I would cite as the reason for miscourt in those cases. I think that the additional information we've been able to provide today, that his current location for mailing is the Job Center 1819 Aberg. And from what he's told me, that suffering from some homelessness, that could be an explanation for why he didn't receive the notices in those 2 files and subsequently missed court in those cases. In the other files, I did have a chance to briefly discuss with Mr. Boyce. He is represented in those files, but he did seem like there was some confusion about when that court date is. He believed it was on 12/6. Obviously, the warrant would have been authorized already on 12/3 and issued out. But that I do think is some explanation for why he wasn't there on those days. Understanding it could be he could have turned himself in quickly and ultimately he was arrested at home. I do think the fact is that it was open for roughly a month. These aren't the longest warrants we've probably all seen here, and I do think that cuts in his favor a little bit. Furthermore, I would just add that he has strong ties to the area. He's lived in Dane County in Wisconsin for the past 20 plus years. He currently has some kids in the area, 2 children, and right now does not have employment, but I do think he still has strong ties to the area, Your Honor. Finally, I would just note that I understand the state's concerns for the victim, but I am open to being corrected if I'm wrong, but I believe in my review of the complaints, there's at least multiple of the complaints where no 72-hour contact was asked for or was enforced, and I do think that's the victim making their wishes known, at least to an extent. So I'd ask that be considered as well.
All right. Well, I'm not going to hold the failure to appear on November 20th against Mr. Boyce. I'm not sure whether he had notice of that particular court date or not. And then in the 25 CM 2925, I think that just went out on a complaint warrant. So there wasn't a failure to appear there. The history that's pretty concerning is he had cash bail in multiple cases, failed to appear, I think, at least 3 times in each of those cases. And that's all after the initial appearance when he knew he had an obligation to keep his address updated. And then we've got the concerning fact that a lot of these cases are actually Act 3 eligible offenses where there's continued violations of the bail with respect to this victim. He was already not supposed to have contact with them, and then allegedly is battering them. I don't see any way around cash bail that's consistent with the public safety assessment report. It notes that he's at the very top of the scale for new criminal activity and failure to appear. And my understanding of that is that's a very rare occasion where somebody actually is all the way at the very top of the scale. There's a failure to appear history in his favor, though there's not a significant prior violent history. Doesn't have any prior convictions aside from the crimes of violence that are alleged in these cases. I don't see any way else than cash bail. Quite frankly, the state would be well within their purview to ask for the $150 to be forfeited in both those cases. That actually be consistent with the statutes to say when you don't show up in court or you violate conditions of bail, the bail should be forfeited. I'm not going to do that because they're not asking for that. And obviously that's a situation where those statutes, while they command that, can readdress that if it's not in the interest of justice. So I'll set $500 cash bail in the 2 bench warrant cases. Prior conditions will remain. In 25 CM 2687, I think the state's request for $500 cash bail and a no contact director and director Elizabeth S. and a ban from the 300 block of Powers Avenue is appropriate. In 25 CM 2925, I'm willing to set a little bit lesser cash there. I'll set that as $1,000, taking into account his indigence. No contact director and director Elizabeth S. And I guess I'm not sure why a ban from 300 Powers Avenue wouldn't also be an appropriate condition. I'm not sure that I heard that requested.
I would ask for it at this time.
All right, I'm gonna order it. I think it's an appropriate condition. And we'll be adjourned. Good luck, sir.
Yeah, this way, sir. Next is Joshua Knack.
Sure, it'll Just be a second for the clerk.
Or, yeah. As I hit print, it disappeared. I was like, son of a gun. Yeah, yeah. It did it to me yesterday too once. Did you order the one from on that last one?
I ordered the ban of the 300 Powers Avenue for both of the new cases, just to be consistent.
All right, you should be good.
Josh, what was that? Nat? Before? Yellows.
Right, we'll go on the record in the state of Wisconsin versus Joshua Nack. It's 26 CF 98 appearances.
The state appears by Assistant District Attorney Thomas Valerio.
Joshua Nack appears in person in custody with attorney Miles Leon. We have received a copy of the complaint. We would waive any further reading at this time. He is eligible for the public defender, and I believe he also is using the job center as his current address.
Okay, we'll get that updated. Since you're gonna use the job center, it might make sense to sign up for text message reminders if you've got a cell phone. When we're done here, you can ask them about that when you're filling out your paperwork. I'll make finding of probable cause, enter a not guilty plea to the misdemeanor. The Public Safety Assessment Report recommends a signature bond. What's the state's position on bail?
I have no objection to a signature bond. I would ask that the defendant not operate a motor vehicle, that he not use or possess any alcohol, that he be referred to pretrial services for alcohol monitoring. This is an instance where Mr. Nack is facing a prison level OWI offense where he PBT'd at a 0.23 at the jail. So I think that pretrial services is appropriate.
Right, and I don't know that I can order pretrial services or I can order it, but he won't be actively monitored until they have the capacity for it. I think like yesterday was the last day that they thought they were gonna be able to take referrals.
Got it.
Attorney Leon, any objections?
No, Your Honor, we'd be joining in the state's recommendation.
If I had the availability and the option of pretrial services, I would certainly require that. I don't know that he's actually going to be able to be in pretrial services, but as I understood their email, I can order it and then they will, he'll be on a waiting list. So I'll order the signature bond with pretrial services. When you're notified that you're eligible for that, then you need to report to pretrial services. They're on the 5th floor of the Dane County Courthouse. The deputy's giving you the map there. So when they inform you that they're able to take you, make sure that you get there and show up.
Okay.
You're going to be equipped with a breathalyzer or a bracelet to monitor your alcohol use. I'm going to order obviously that you not operate a motor vehicle and that you not possess or consume any alcohol at all. And Mr. Nack, we're getting into some high level OWI offenses. You come back here with another one. I can tell you in my experience, the state's probably going to be asking for cash bail. So I don't know that you want to put yourself in that position. Okay. What about time limits for a preliminary hearing?
Thank you, Your Honor. I did have a brief moment to discuss that with Mr. Nack, understanding that the signature bond was just set. He's okay with waiving time limits in this matter.
Okay, we'll be adjourned.
Thank you. Waived.
Yeah.
Waive time limits, yeah.
Next is Jesse McKnight.
Thank you.
All right.
All right, we'll go on the record in the state of Wisconsin versus Jesse McKnight. That's 26 CM 108 appearances.
The state appears by Assistant District Attorney Thomas Valerio.
Jesse McKnight appears in person in custody with Attorney Miles Leone. We have received a copy of the criminal complaint. We would waive any further reading at this time. Sorry, Your Honor.
Sorry.
He is eligible for the public defender, and the current address for him is 509 North Lake Street, 510 Madison, Wisconsin, 53703. Lake, North Lake Street.
An apartment 510.
I believe so, Your Honor.
Correct. Thank you.
Correct.
Yeah, I think that's consistent with what's on the complaint. We'll make a finding of probable cause and are not guilty pleas to the charges. There's a PSA report that recommends a signature bond. What's the state's position on bail?
I have no objection to a signature bond. I would ask that the defendant not use or possess any alcohol and that he be banned from the men's shelter, which is located at 2002 Zaire Road.
Great. Any objections to those conditions?
We would object to the non-monetary condition at this point. He's just saying that he will be homeless if he's not able to go back to the men's shelter. Obviously, if that's going to be the difference between a signature and a cash bond, I understand, but at this point, he doesn't have anywhere else to go, and we would be objecting to that condition.
Okay, any response from the state?
Well, he PBT'd at a .313 when he was ultimately booked in the jail. And in this case, he's drunk at the men's shelter and trying to fight not just other patrons, but staff at the men's shelter, who, by the way, deserve to be at the men's shelter peacefully so that other individuals who are housing insecure can remain there safely and sound. I don't think it's an unreasonable request to have Mr. McKnight banned from the men's shelter after this disturbance. So that's my position.
Okay. Right.
He has, and yeah,
So-
I apologize.
Mr. McKnight, I don't know that you want to say anything out loud because we're recording and it can be used against you and you have the absolute right to remain silent. Attorney Leone will listen to what you have to say and he can make sure you don't say anything that incriminates him.
Thank you for the moment. After speaking with Mr. McKnight, he's informing me that there's possibly some kind of room that are used for people if they've been at the men's shelter and have caused issues in the past. He refers to it as a disciplinary room. I'm not sure if the court would be willing to entertain maybe some kind of condition that maybe splits the difference and I guess leaves it up to the discretion of the men's center whether they would allow him to be there, especially if they have access to this additional room that he's telling me about. I don't have a great idea of how we can enforce that or how the state would be able to monitor that, but I do think maybe leaving it to the prerogative of the entity itself and to the men's center would kind of solve the problem here, Your Honor.
All right. And the underlying case, was that something that involved the men's shelter on Zaire Road, or is that completely
No,
separate conduct?
That's at the Madison Library, but and looks like he was banned from there.
All right. Well, I guess as I understand the complaint here, it's primarily him being extremely intoxicated, belligerent, but not physical violence. I think they were concerned that there was the potential for that, but that doesn't allege that. I would think that the shelter can say, Mr. McKnight, we don't want you back. And I guess I'm gonna leave it up to them to decide, and hope that the condition of not to possess or consume any alcohol is gonna rectify all of the issues. Mr. McKnight, so I'll order a signature bond that you not possess or consume any alcohol. I'm not ordering the address ban. That said, if they say you can't come back, obviously they're not gonna let you in, they're gonna call the cops and then you'd be trespassing, and potentially back here. So you'll have to abide by whatever their decision is. But I want to leave the option open if they think they can safely manage you and all the other people are gonna be safe, that then you can be there. All right, we'll be adjourned.